1005, Matthew Doyle versus the state. Jacob Rhein for appellate, Mark Mellon for appellate.
May it please the court, Jacob Rhein on behalf of the appellant, Matthew Doyle. This case is about whether a guilty verdict can be upheld in a murder case when the trial court's instructions to the jury contradict the charge on accomplice corroboration and the corroborating evidence is less than slight and merely raises a grave suspicion of the defendant's guilt. I will first address plain error in failing to charge on accomplice corroboration, and will then briefly address the issue of insufficiency of the evidence. Because Doyle's counsel made no objection at trial, this court reviews the jury charges for plain error under Kelly versus the state. And there's 4 prongs under Kelly, which the court is well familiar with: an error which is obvious, which likely affected the outcome at trial, and which seriously affected the fairness, integrity, and public reputation of the trial. I'll go through each of these prongs. First, error. The trial court erred in failing to charge the jury on the requirement of accomplice corroboration because there was at least slight evidence in this case that Richardson was an accomplice. The state's evidence authorized the jury to find that Richardson first matched the description of the shooter given by the only eyewitness who testified. Richardson is bald and he is African American and was driving a blue SUV at the scene of the crime at the time of the shooting. That's the description of the eyewitness. Secondly, Richardson drove the defendants to the scene of the crime after hearing them discuss hurting someone and getting payback for at least 20 minutes. So he knew that a crime was about to occur. If the detective is to be believed, Richardson saw the co-defendant Parks rack an AK-47 in the front seat of the van and actually saw my client shooting. And after having seen that, he then drove the defendants away from the scene of the crime after hearing gunshots and fails to report the crime to law enforcement.
You said if the detective is to be believed, who does the crediting?
The jury, of course, would weigh the evidence regarding the believability of the detective. But there's at least slight evidence in that testimony that would support a finding that Richardson is an accomplice.
Counsel, in terms of the jury charges that were given, was there a charge given on the testimony of a single witness can establish a fact?
There was, Your Honor.
Okay,
And this case is squarely decided under Stanbury versus the state. I understand that there are a number of cases in which that charge was not given. The violation in this case, and I'll just move right on to the obviousness of the error. In Stanbury versus the state, the judge gave a charge that this gave the single witness instruction. Here the court actually went further and said the testimony of a single witness is generally sufficient to establish a fact, and generally there is no legal requirement of corroboration. So she contradicts the rule even more directly than was done in Stanbury. This was a very obvious error. The error is also obvious because the trial counsel raised the issue of corroboration in his motion for directed verdict. And in response, the trial court basically usurped the role of the jury and said, well, there is sufficient corroboration even if Richardson's an accomplice. And so it was squarely presented to the court. The court should have been on notice that that there was an issue of corroboration under the plain language of the statute. I would also point out that under Stanbury was decided under the plain language of the statute. So even though there was some precedent in Ham at the time that might have perhaps been confusing to the trial judge, the plain language of the statute controls, and Stanbury was also...
Let's look into that then. Ham was overruled in 2014.
Correct.
Trial in this case was what year, do you recall?
2010, I believe, Your Honor, or 2011.
So you'd have to argue that trial counsel was deficient in relying on those prior cases?
No, the error here is plain error, not an issue of ineffectiveness.
Well, the judge is obvious, notwithstanding the prior case law.
But we've held for plain error, the point that you decide if it's obvious is when the case is on appeal, right? You
correct.
didn't cite that, but we have cases following the U.S. Supreme Court's plain error doctrine. That
Yes, Your Honor. Yes, Your Honor. I would also point out that in Stanbury...
It's a little odd that the trial court commits an obvious error that It's actually consistent with the law at the time, but that's what we've said.
Yes, Your Honor. Although I would note that even under the holding in Stanbury, the charge was not consistent with the law at the time because it contradicts the plain language of the statute. And Stanbury had the same facts here. Stanbury was decided in 2010, which is also before Ham. This court found that there was plain error because of the plain language of the statute. And so the court can look, the unequivocal language of the statute says that you have to have corroboration if the only witness is an accomplice. In considering the point of harm, this court considers whether there's a reasonable probability that the outcome would have been different. And this analysis requires the court to consider the evidence presented in this case, which was far from overwhelming. In order to support a conviction on accomplice testimony, the state had to present evidence of corroborating facts or circumstances which, in themselves and independently of the testimony of the accomplice, directly connected Doyle to the crime or led to the inference that he was guilty, and were more than sufficient to merely cast on Doyle a grave suspicion of guilt. Here, the only possible independent corroboration of Richardson's testimony against Doyle was presented by the state's police detective in the form of a prior inconsistent statement. Specifically, the police detective testified that another witness, Carrie Henderson, had told him that she overheard Doyle, or Matt, admit to shooting the victim. The police detective's testimony was a prior inconsistent statement because Carrie Henderson testified that she did not recall her conversation with the detective. As a result, the jury had reason to doubt Peavy's testimony, the detective's testimony. But because the trial court charged the jury that the testimony of a single witness is sufficient, it is entirely possible that the jury convicted Doyle solely on Richardson's testimony without considering whether it ought to believe or disbelieve the detective. And this goes to your question, Justice Warren, about who decides. The jury did not have an occasion to ask whether it needs to believe Peavy or not, because it was instructed that it could convict solely on Richardson's testimony. The jury therefore lacked proper guidelines for determining Doyle's guilt or innocence. It's the same issue in Stanbury. Additionally, the state actually argued single witness in closing argument and told the jury that if they were unhappy with how the state dealt with Richardson by not charging him in this case, the jury should take it up with the district attorney and the chief of police. So it's just not possible to say in this case that the erroneous charge did not contribute to this verdict. Finally, the violation seriously affected the integrity of the trial. As this court recognized in Stanbury, the trial court's contradiction of an accomplice corroboration rule leaves the defendant with no way of knowing whether he was convicted through permissible means. To affirm the conviction of Doyle on these facts would render the accomplice corroboration rule meaningless, and the court should therefore exercise its discretion as it did in Stanbury and grant Doyle a new trial. Unless there are questions, I'll move on to insufficiency of the evidence. Richardson's testimony, Richardson is the accomplice, his testimony, if believed at all, proves that he was an accomplice before, during, and after the fact. Because Richardson is an accomplice, the only possible corroboration in the case, because he's an accomplice, you need to find slight evidence directly connecting Doyle to the crime. The only possible corroboration in this case is the inconsistent statement that comes in through Detective Peavy. But here's the problem with that testimony. Nothing in Detective Peavy's testimony directly connects the alleged admission to my client, Matthew Doyle.
So what's your best case for the scope and nature of the corroboration that you're arguing was required? Because what is required to be corroborated is, as I understand it, is the accomplice's testimony generally. There does not have to necessarily be corroboration on literally every point, right?
No, Your Honor. However, it does need to independently directly connect Doyle to the crime or lead to the inference that Doyle was guilty. So it's not enough to just say, well, Richardson said a bunch of things about various people, and there's evidence that supports what he said about some of them. There needs to be independent evidence directly connecting.
There needs to be independent evidence on literally every point?
No, but something directly connecting each each other co-defendant to the crime. So this court addressed the issue of sufficiency of the evidence in Parks, and it went through a short list of corroborating evidence against Parks. There was, for instance, some cell phone records showing that Parks had been driving around South Atlanta on the night in question. Some people had seen Parks with Richardson that night. That's the kind of independent corroboration that would support a conviction here. But in this case, none of that corroboration actually says anything about whether Doyle was there. And I mean, the reason for the accomplice corroboration rule is sort of demonstrated in this case because Detective Peavy goes to Richardson in jail and says, you need to accuse Matt Doyle as the shooter. And if you don't, it's going to be warrants for everybody. I mean, he pushes Richardson very hard. Richardson at first says, I don't even know Matt Doyle. He then goes to praying. He finds Jesus in jail like 3 days later, and he calls the detective back and says, oh, you're right. You know, now that I think about it, I do know Matt Doyle, and he was there. And as a result of making that testimony, apparently, he avoided being charged with murder in this case.
What is the problem with the prior inconsistent statement?
The problem with the prior inconsistent statement is that Detective Peavy's testimony only says that Kim Henderson told him that Matt admitted to shooting Pookie. But Henderson doesn't, Peavy doesn't testify to anything that connects Henderson's statement to Matthew Doyle. And Henderson herself denies that she recognizes Matthew Doyle in the courtroom. And so
why is that inconsistent with her? Is that inconsistent with her own statement?
So Henderson says that she doesn't recall her statement with her conversation with law enforcement.
Okay.
But she also says affirmatively, I don't recognize the person that you're referring to as Matt in the courtroom. I don't know who that is. I don't know who you're talking about.
Why isn't that just a credibility determination for the jury to make?
It's not, because there's no evidence actually to support the jury's verdict. There's simply no evidence that the person...
She said Matt, basically Matt admitted it, right?
She doesn't say that.
Okay,
Peavy says she said Matt admitted it.
Yeah, we take that as true, as if it were substantive evidence that she said it from the witness stand, right? That's how hearsay exceptions work.
Okay.
Right? So Matt, what'd she say? Matt did it, or?
Matt admitted. There's an issue, a side issue, which I'd rather not get into regarding State's Exhibit 9. I've briefed it. But essentially, yes, what Detective Peavy says is that Henderson said that Matt admitted to shooting Pookie.
Okay. And your client's name is Matthew.
Yes.
Okay, the jury knows that?
The jury does know that my client's name is Matthew. However, there's two problems here. First of all, there are a lot of people named Matthew in the world. Simply saying Matthew admitted, if there's not an identification of Matthew, identification of the defendant is an essential.
For sufficiency, we're going to make, unlike for harm, we're going to make all reasonable inferences that a jury could make. Are you saying it's not reasonable when the detective is asking the whatever she was, girlfriend's cousin of defendants in a murder case, and says that she said Matt did it, that the jury could reasonably infer that she was talking about Matt Lauer from the Today Show?
No, I'm not saying, I'm not, I mean, that's maybe an extreme example, but I mean, I am saying there's no evidence in this case that connects the alleged statement by Henderson to Matthew Doyle, and she actually says the opposite of that.
But is there any other piece of evidence in the entire trial that could have connected your client? Because if so, isn't the jury allowed to make reasonable inferences and put them together?
The problem is there's nothing else.
Cell phone records?
Sorry?
Cell phone records?
They show Parks, they show the co-defendant was driving around, but nothing about Doyle. It's all down to this issue. The best case that I have on point regarding this is Hill versus the state. It's cited in my brief, I believe, at page 21. In Hill versus the state, the independent corroborating evidence that was presented, or that was argued by the state, was a ski mask. But the problem was, even though we have a ski mask, it's not clear who owned the ski mask. And in this case, even though we have an admission, it's not clear who owns the admission.
But if you had a prior inconsistent statement in that case that Hill, or whatever Hill's first name was, owned the ski mask, the case could have come out very differently, right?
Yeah.
I mean, I guess to boil it down, we have to say jury cannot reasonably infer that when somebody connected to the people in the case refers to one of them by their first name, that they can reasonably infer that it is the person involved in the case and not some random other person with that first name?
Here's why you can't do that. Because the corroborating evidence needs to be independent of the testimony of Richardson. And so the only reason that we think at all that Matt Doyle is connected to this crime at all is because of Richardson. So you might say, well, the jury was authorized to believe that was authorized to make some sort of inference, but if it relates at all to Richardson's testimony.
Now, we also believe it because if you credit the inconsistent statement, she said Matt killed the victim, right?
Right, she said that about Matt, but she says—
We don't rely on Richardson for that. We rely on this witness saying that Matt killed the victim.
That's true, but again, the issue of identification, I mean, the whole point of the corroboration is that there needs to be something else that we can actually identify the defendant with. How else can we identify that he was even there?
His name was Matt, right?
Testimony. His name is Matt.
Okay, and she said Matt killed him, right?
Yes.
Okay, why doesn't that do it?
Well, I think that what it does, I mean, the way that the statute is written, the way that the cases have come down, we need to find something that's more than sufficient to merely cast on Doyle a grave suspicion of guilt. I think that this does cast on him a grave suspicion of guilt, but it doesn't get to the point of
The corroboration itself doesn't have to be sufficient. It just has to be slight corroboration.
It does have to be slight corroboration. Okay. But specifically, the court needs to be confident that corroboration is independent of Richardson's testimony, including any inferences that could be drawn. The inference would have to be an independent inference from Richardson's testimony.
To the extent the corroboration is an inference, but when you have a person who said Matt killed the person, Matt did the shooting, that's not an inference, that's a explicit statement, right?
The defendant,
the only inference is who Matt is, right?
Yeah.
Well, the police detective doesn't have personal knowledge about who Henderson was talking about.
Okay. I mean,
Let me ask it this way. If the only evidence in this case were this prior inconsistent statement, couldn't we find that under Jackson v. Virginia, wouldn't that be sufficient evidence to convict your client? That a prior inconsistent statement comes in as substantive evidence saying Matt, who is associated with the witness and has the same first name, killed the victim. Isn't that sufficient evidence as a matter of due process to convict for murder?
I think that actually the answer to that question would be no if there's no in-court identification of Matt of the defendant as Matt. You need to connect up those two pieces of evidence. If someone comes into court and says, Matt admitted to shooting Pookie, and there's no in-court identification of Matt that's actually connected to that statement, you can't just convict because the person's name was Matt. That's a bridge too far for reasonable inference. The jury is only authorized to find what the evidence allows.
and so it may be that, depending on circumstances, that might not be independently sufficient, but it's plainly corroboration.
I'm not sure what you mean by that. It's not.
So you have an accomplice who testified that your client did this. You then have a separate person who says Matt did this. I mean, that's corroboration.
Well,
It may not be independent sufficient evidence, but it is certainly as corroboration.
Well, corroboration is as I'm using it, corroboration is a legal conclusion about whether there was sufficient evidence corroborating the accomplice's testimony. That actually does need to be independent and directly connecting Doyle to the crime. Doyle specifically, not just an abstract person named Matt. And it's not enough to just, reach out and assume that PV must mean the defendant who he fails to identify in court.
Well, would it be enough if the statement had said Matthew Doyle admitted that he did it? That would be less ambiguous, but there would still be some ambiguity, right? So your argument would be not even that's enough.
I think that's a closer question. I certainly think that's a closer question. However, I still think that the identification of the defendant in the courtroom is an essential element.
That's just not how we do sufficiency review under Jackson v. Virginia. We draw all the inferences in favor of the verdict, not drawing all the inferences in favor of a reasonable doubt.
And let me ask you this. How could hearsay from an out-of-court declarant ever come in at a criminal case if it has to be accompanied by an in-court identification of the person the declarant is talking about?
Well, I'm not saying that it has to be. I'm just saying that in order for that inconsistent statement to count as corroboration under the statute, there does have to be that sort of connection. Thank you, Your Honor.
Thank you. Mr. Mallon?
Thank you, Chief Justice Melton, Presiding Justice Namias. May it please the court. I would like to refer the court to a couple of record sites that I hope will clarify that Keith Richardson, if he were an accomplice, although I'm going to argue that he is not, if he were an accomplice, he was adequately corroborated. And
That goes to the sufficiency claim. But as to the plain error claim, whether or not there's evidence that could have corroborated him is not sufficient to defeat the claim of plain error, right?
ordinarily, that's correct. We think under Ham, though, and I didn't realize it had been overruled, but I'm trying to argue that the basis for the girl's testimony, Kim Henderson, is Park's admission that the both of them, they shot Pookie. That's the basis for it. It's a co-conspirator telling somebody the day after. She says, Lewis and Matt show up at my house. They told me they shot Pookie. Matt did the shooting.
Okay.
That's the basis for her original statement to Peavy, which is why it can come in as prior inconsistent.
And I don't think Ham's been overruled. I think Ham overruled the case law
Right.
the trial court was relying on. But
Oh, yes.
so I wouldn't worry too much on the corroboration side, but plain error.
Right. And in this case, Richardson identified the defendant, Matt Doyle, in court, and State's Exhibit 46, the photographic lineup. He knew him. He bought drugs from him.
So Richardson, if he weren't an accomplice, you got plenty of evidence. Richardson is a single witness.
Right. Well, and also that leads to the reasonable inference that the Matt that came to her house is the defendant.
The sufficiency issue, but for
Right,
plain error.
but it also goes to, I believe, that the absence of the accomplice corroboration charge does not require a new trial in this case, because that is also supported by the evidence of the neighbor, Xavier Lewis, who said he heard shots, saw two men apparently shooting, a big guy outside, and someone leaning out the passenger window pointing as if he were shooting. Now,
what's your best case for finding no prejudice
Ham.
in the absence of accomplished corroboration charge when the single witness charge has been given? Was a single
I
witness
believe
charge
those are
given
the
in Ham?
circumstances in Ham, that the admission plus additional corroboration ultimately renders the absence of the charge harmless. And that is actually my fallback position.
Was a single witness charge given in Ham?
I know the corroboration was not.
Right, but the key thing is whether single witness was.
Oh, the difference between incomplete and objectively
If a single
mistaken.
witness charge is given, the jury is invited to convict based solely on the testimony of the accomplice.
Right.
And so the presence of that charge in the absence of the accomplice corroboration charge creates serious problems for us concluding a lack of prejudice.
Right.
And so what I'm looking for is if you know of any cases in which accomplice corroboration was not given, single witness was, and we nevertheless said no prejudice.
I believe there is one, our Jackson case from last term, which spends
The last term, okay.
several pages going over lots and lots of corroborating evidence.
Well,
Ham had
I would respectfully submit that the association of the Matt who's been identified as Doyle with Parks.
Right, so there is maybe sufficient evidence, but what you have is a single statement that's only admitted as a prior inconsistent statement and refuted by the witness at trial, or?
And you've got the neighbor who says, I saw two guys, a big guy outside shooting, and somebody in the passenger seat pointing as if he were shooting. Now, if Richardson were an accomplice and were leaning out the passenger seat, he'd have to climb over Fat Lewis to be able to get through the passenger window. He was the driver.
So the neighbor says he saw two
Yes.
people shooting, two different
Well,
people
big guy
shooting?
outside shooting and somebody leaning out the passenger window as if he were shooting, pointing. And the medical evidence is that he was only hit by the 7.62 caliber bullets.
And based on the neighbor, how do we know that that third person wasn't Richardson's best friend who he's trying to cover up for?
I think the physical similarities there, big guy, bald, or wearing a skull cap, that's,
Does that fit Richardson too?
I do not know
I think your
whether
opposing
he is a
counsel's-
big guy or not,
Does the record indicate it?
not to my knowledge.
Well, then it can't be corroborating evidence if it's not in the record, right?
No, it corroborates the description of Doyle, not Richardson. Richardson's the driver.
According to Richardson.
Well,
Other than
no, there's no evidence that he was other than the driver. The girlfriend of Richardson says,
It's not how corroboration works. I'm trying to take Richardson out of the case. He's not at trial. What evidence do you have that,
you have the co-conspirator's statement to Ms. Henderson the next day that we did it.
That
Matt
she-
did the shooting.
that she disclaims at trial?
Yes, that she could not, well, she could not remember telling Peavy that, Detective Peavy.
Okay.
And that's why you have the two hearsay steps to authorize the admission, the underlying admission by the co-conspirator. And that, I think, is highly corroborative of what Richardson said. And so,
And the neighbor saying saw two people. Is there anything else at all?
that leads to the identity of Doyle as the shooter. No, I do not believe so. But again, I submit that because of that very corroborative, incriminating admission by the co-conspirator, that the absence of the accomplice corroboration, even in the context of
So
the single.
normally when we talk about harm, we use terms like strong evidence and overwhelming evidence. You're saying a double hearsay, I don't remember it at trial statement is strong or overwhelming evidence?
Yes, because she admitted from the stand that she had been threatened to lose her memory.
Fairly remarkable to me that you would characterize that as overwhelming or strong evidence.
The admission that they shot, yes, I do. That's, I mean, the defendants,
Now,
they know what they did.
Maybe the admission by a nun who is not cross-examined at all, but the admission by a witness recounting co-conspirator hearsay, well, by a detective recounting double hearsay that the witness says at trial, I don't know nothing about it.
Right, after
That
being
is-
threatened, yes.
That is overwhelming evidence.
Because of the nature of the liability that it invokes. If the court has no further questions, I will rest.
Do you have an argument about Richardson not being an accomplice?
Oh,
You
yeah.
kind of started with that. but
He's
then-
an accomplice after, an accessory after the fact. He had no knowledge that they were going to be doing a shoot-up. There's evidence that he was instructed, he was a do-boy for Parks, and he was instructed to drive Parks to some club to pick up his son. That was the information he was given. They get there, they wait 20 minutes. The other passengers in the vehicle are the ones discussing whether there needs to be payback or retribution. And there's no evidence that Richardson had a common criminal intent. He may have seen a gun in Parks' lap.
So for party to a crime, which the state often asks us to affirm on sufficiency grounds, which is similar to slight evidence, we say that common companionship, association, and conduct before, during, and after the crime can create an inference of common criminal intent. Here you have him with the other defendants before the crime. There's evidence the jury could credit that they talked about committing the crime on the way there and had a weapon that he saw. He sees them commit the crime. He is the getaway driver and then conceals it. In many of your briefs, you would argue that if you had charged Richardson as an accomplice and the jury had convicted him, we should affirm that based on the case law saying companionship and presence before, during, and after.
Well, if
But
the
here you said
evidence
there's not even
showed...
slight evidence.
That's right, because the discussion, I mean, I guess you could say that you could draw an adverse inference, but the evidence is that the passengers discussed this payback, and even that, if he saw a gun, that doesn't mean he intended to participate and presence, even approval, not amounting to encouragement, is not sufficient to make one liable as a party to the crime. So I think he's only an accessory after the fact, which is not an accomplice. Any further questions?
Thank you, Counsel.
Thank you.
This court will be at recess until 2 o'clock.